The 4th of July holiday is coming up and many people will be having barbecues and parties, but there are certain legal responsibilities for the host, particularly when it comes to serving alcohol. For this week's Legal Edge, I asked local attorney Bryan Waldman, could a host be liable if one of their underage guests left their party drunk and caused a crash?
In some cases they can, Siobhan. That's called social host liability. And in Michigan, the laws regarding social host liability really focus on making sure that people don't serve alcohol to minors or serve alcohol to people under the age of 21. There's a law or a statute in Michigan that says it's a crime to serve alcohol to someone under the age of 21. It's a misdemeanor. If the service of alcohol ends up resulting in the death of the minor, it's a felony punishable by up to 10 years in prison. And beyond that, there can be civil liability.
So how would civil liability play out in a situation like this then? Who could sue or bring a claim?
Well, you can imagine a lot of people can be harmed or hurt when you bring alcohol into the picture, particularly serving it to a minor. So, if you can envision a situation where a social host, someone hosting a party, serves alcohol to a minor goes out, gets in a crash because they're under the influence and injures another person. That person who's injured has the right to sue the social host or bring a claim against the social host for serving the minor. But also the minor, if they're injured in the crash, could also bring a lawsuit or a claim against the social host for violating the law and causing them to be injured.
Even though the minor's under 21, they're still old enough to know kind of what's right and wrong and should have some personal responsibility for what happened though, right?
Absolutely. And the law does take that into account, Siobhan, in a couple ways. First of all, the injured person who's not the minor, the person that the minor strikes or injures, they've got a claim not only against the social host, but they've got a claim against the minor who consumed alcohol and went out and drove. If they're old enough to drive, they should be old enough to know they're not supposed to consume alcohol and get in a car. Beyond that, even though the minor has a claim against the social host, the law has something called comparative negligence, where you look at the relative fault of the different people involved in the lawsuit. So here you would compare the fault or the conduct of the social host with the minor. And if the judge or the jury determines that the minor who consumed the alcohol is 50% or more at fault for the crash as compared to the host, they would receive nothing as a result of that lawsuit or be entitled to nothing.
Bryan says the lesson here is if you're hosting a party and alcohol is being served, you need to be very careful to do it in a responsible way.